I'm going to talk to you all a little bit about litigating Batson on appeal, what to look for, how to preserve error, how to present it on appeal. And there's going to be some slight repetition as to what some of the other speakers have already talked about. So there are a couple of things to keep in mind. You make your objection after the strikes have been made, before they impanel the jury. Your client and the members you're saying were struck. They don't have to be of the same race. Your client doesn't have to be a minority at all. So it's really, like they were saying, it really is, it's the right of the juror to serve on the jury. It's not necessarily that you represent a minority client and so your minority client needs minority jurors. So there's a three-step process. You first establish the prima facie case. The burden then shifts to the state to give a race-neutral reason, and then the trial court decides whether they believe the race-neutral reason or not. And a lot of times, I mean, they're going to side with the state, because on the surface, the state will often give reasons that seem race-neutral. So how do you establish a prima facie case? There's a couple different ways. You can look at the pattern of their strikes, the percentage of their strikes. Were more minorities struck on your panel versus others ratio-wise? Did they question the people they're striking? Did they even talk to them? Are they just, deciding they don't like it? Some of the things to look at also is disproportionate questioning. I assisted with doing a death penalty case. We had a Batson challenge. And we saw things like, you'd have a panel and they would have some people with children. And for the non-minorities, oh, okay, you have a school-age child, that's great. For the minorities, well, what time does that child get off school? And who picks up that child? And if you're gonna be here for a long period of time serving on this jury, how could you reliably have childcare? And it basically just gets them to the point where, you know what, it's probably too hard for them to serve on the jury. That's why we struck them, not because of their race. But they weren't asking the same questions of the non-minority jurors. What was really interesting about that one is that we didn't have all of the race information, so we got to go track down the prospective jurors and take photos of them with their juror numbers so we could prove what race they were, because we didn't have all the juror cards. So the state's race-neutral explanation. Now they're going to give all sorts of race-neutral explanations. They scored law enforcement a certain number. They, I didn't like him because he had long hair. I didn't like him because he's a single father and who's going to take care of his children. So one thing to look for are questions, particularly like they were talking about, where minorities may be more likely to answer the question differently. Law enforcement questions, questions about how do you feel about prosecuting drug cases is a big one that I've seen. Another thing to look at is, are the reasons they're challenging that juror even related to the facts of the case at all? They had some cases where there was, they said that they struck somebody because they lived in a particular area of town. Well, that particular area of town happened to have a larger population of minority residents. That area of town and where they came from had nothing to do with the case. So, the appellate courts found later on that, yeah, no, I mean, you're saying that you're doing it for this reason, but that's just really a ruse. Two things to keep in mind is just saying, I don't agree with their explanation doesn't mean that you win. Just showing that their explanation is wrong doesn't necessarily mean that you win either. A lot of it really will kind of depend on the judge and how the judge is viewing the whole situation. Okay, so in Miller-El, the Supreme Court put a couple of factors forward. These are the things that they use in assessing the true motives of the peremptory strikes. It's not an exhaustive list, but these are things to look out for. Did they eliminate a far greater proportion of minority members than non-minorities? Were the stated reasons for striking the minorities, did they equally apply to the non-minorities that were not struck? The jury shuffle. Did they use a jury shuffle to kind of move the minorities, hopefully, to the back? Did they single out minority members for questioning in a way designed to elicit grounds for peremptory challenges? and whether the party employed a formal policy to exclude minorities from jury service. I think a lot of the DA's office probably have gotten a little bit smart about having like written policies. About how, we don't put these particular people on the jury. But one thing to look for is, for example, if you get to question the ADA on a Batson hearing, does your office have code words? Does your office have code words that go with specific minorities? Does your code word, are you not supposed to have Canadians on the jury? Are you not supposed to have, Europeans on your jury? Also, can you get the evaluations of that particular ADA and see if that particular ADA has kind of had a history of maybe, having Batson challenges lodged against them? Things like that are very, it's going to make an ADA on edge and say, you're calling me a racist. Well, it might just be they're kind of things that are ingrained in you. Like somebody once told me that you shouldn't put Asians on a jury because we follow the law and we are less likely to be defense-oriented. Like, oh, okay, well, I'm a defense lawyer, so that kind of doesn't fit. Appellate review. So during the Batson hearing, both sides have to state their reasons for, the state has to state their reasons for striking that prospective member. You have a chance to kind of address that. At this point, really, if the trial court doesn't allow you to have a Batson hearing, the appellate lawyer then should have it abated for a retroactive Batson hearing, which gets very complicated because you've got to dig through all of that. But the hearing does have to be there because you do have to have all those reasons on the record. The appellate standard of review. Now, this seems like a pretty difficult standard to meet. The trial court's ruling must be sustained unless it is clearly erroneous. The state is bound by the reason or reasons it proffers at the time of the Batson hearing. That doesn't mean that they can't look outside of what happened. They also do tell you, it seems a little bit contradictory, you look at the totality of the circumstances. A lot of what that is some of the courts will engage in a comparative analysis, which it's much easier to explain. There's a graph that explains that. Evidence is viewed in the light most favorable to the trial court's ruling. And so to get a case reversed on a Batson issue, the appellate court must have a definite and firm conviction that a mistake has been committed. A lot of times if they are giving you reasons like, well, I didn't like the way he looked at me. He rolled his eyes when he answered that question. On appeal, you're kind of stuck because, the trial judge was the one who saw that. That's not in the appellate record unless you build it into the appellate record. So how do you preserve your record for appeal? Include the race of the panel, the race of the members that were struck. If the ADA uses their notes that they made to testify in their Batson hearing, you're entitled to have those notes and make those notes a part of the record. Enter the juror information cards as an exhibit. Like I said, training manuals, evaluations, are there any code words? Sometimes we don't get the juror information cards. My Batson case, actually, I think Judge Patrick had been on the bench for, I think you had probably just taken the bench. And so we went and took him a motion to unseal juror information cards. It was a motion for access and copying of the juror information cards. And what we explained to the judge was that there was a Batson challenge raised at trial. This is what the state alleged. And without those information cards, we have no way to actually litigate it. I don't think we've gotten too much pushback from the judges. I know Judge Patrick was more than happy to sign it. You go down to the exhibit clerk and you get the juror information cards so you can figure out whether or not you have a Batson claim to litigate. So it has expanded some. It does now cover gender and ethnic grouping along with race. A question still, though, is does it cover religion? So religion is something that it's evaluated under a strict scrutiny rule. So you would think it covers religion. In Texas, the Cazares case, actually, at first the CCA said, yes, religion is protected, and then on rehearing they said, no, religion is not protected. The states are split on this. If this is an issue that you have in any of your cases, it's an issue that's probably pretty ripe for appeal. A lot of the states that do prohibit striking prospective jurors based on their religion, they're basing that on their state constitutions. Their state constitutions that say, any person should be qualified to serve on a jury. You can't exclude them because of what they call a group bias. Just like you can't exclude all members of a race, you can't exclude all members of a certain religion. And we have seen that the state, again, is using religion sometimes as a proxy to cover up for race. There are certain races, there are certain groups in certain areas where they may be more likely to be affiliated with certain religions. I know that, the neighborhood where my son goes to school, there are a lot of Hispanics who are Jehovah's Witnesses. And, they can use that questioning because they're protected. It's okay to strike them because they're a Jehovah's Witness. But really, they're striking them because they're Hispanic. So I know Judge Patrick is here, and I think that you're in trial, right? Okay. I'll just do a really quick case summary, and then I'll pass it along. Robert Nathaniel Jones was convicted, PCS 1 to 4 grams. He got 30 years TDC. During his trial, they look over and they realize that the seated panel had no African Americans. Mr. Jones is African American. So the prima facie case, there were 4 African American panel members left after they did the challenges for cause. The state used 3 of their 10 strikes to strike 3 of them. The 4th one, if I remember correctly, was also a police officer, so that was one that the defense had agreed to. And then when they're making their objection, they object only to 2 of those 3. They make a Batson challenge to 2 of those 3. And one of the reasons the state said, no, this was not a racially motivated thing, they actually did say, well, the defense struck somebody who's an African American too. Didn't make much sense, but that's what they said. On appeal, we really only focused on one of them. Because what the state said, their race-neutral reason, the strikes were based on answers to very specific questions, scaled questions. If they believe small drug possession cases should be prosecuted, how the juror felt about drug laws on a scale of 1 to 3, and how highly they regarded law enforcement in their community. Raised a Batson challenge, it was denied by the trial court. This was actually a very clear case, because this is what we found. We did an analysis of the panel. We made a chart, a massive chart with every prospective juror, the answers to their questions, if they were asked additional questions. So here we have, this is the chart that was included in the brief. We focused on these 4. They all have the exact same answer for all 3 questions. And then we have their races. And the white male, the Asian male, and the white female were seated, and the black female in between those was struck. There was no individual questioning. There was nothing separating those answers from the others. Those were literally the only questions that were asked of this particular juror, number 24. So there was no real reason to, pull her aside. Why are they saying they're basing it on these numbers when this doesn't hold out? And so we raised that, of course, being appellate lawyers and knowing the very low reversal rate, we said, well, it's an interesting issue, but we will likely lose on appeal. Surprisingly, the 14th Court of Appeals found that the state's race-neutral reasoning was not genuine. They used a comparative analysis of the state's strikes and found that the trial court's failure to find purposeful discrimination was clearly erroneous. What they said was that people of different races who had the same or similar answers were not struck. And so this was, to them, proof that the trial court's denial of the Batson claim was clearly erroneous. It was not while Judge Patrick was on the bench. I did want to clarify that this is before Judge Patrick came onto the bench. I think so, too. I think so, too. And the state actually filed a PDR on this, and we were a little nervous because there had been another Batson case that had gone up, and the Court of Appeals had reversed, and then the CCA flipped them on PDR. And I think the reasoning in that one was that the prospective juror gave off a bad vibe. So we were a little bit nervous on this one, but the CCA denied the state's PDR. So that is what stands here. And it really was, I mean, I almost feel like it was kind of lucky. It's not every day that you get a very clear-cut record like that, you know. It was, the trial lawyer on this case Randy Ayers, did a really, really wonderful job of making everything very clear and making the record very clear. So I was very lucky to get that case on appeal because all the work was done for me already. So I'm going to turn it over to Judge Patrick, who's in trial.